Hi, my name's Jane McElligott. I'm a professor at Purdue University Global, and I'm here to discuss the case of United States versus Rahimi, pretty recent case decided in June 2024, involving a key Second Amendment case, also an important case for the issue of domestic violence. Um, the facts in this case go back to December 2019 when Zaki Rahimi was in an argument with his girlfriend. He became enraged. They were in a parking lot. This took place in Texas. Uh, CM is uh, the girlfriend's name, initials to keep her, information confidential. When CM tried to get away from him when he was acting violent, uh, he grabbed her, dragged her back to the car, shoved her in the car, and caused her to strike her head on the dashboard. She luckily escaped from the car when Rahimi saw a bystander watching the incident and went to reach for his gun under the seat of the car. And when he did that, she ran out. Once he got hold of the gun, he actually fired it. But it's not clear whether he shot it at CM, the girlfriend, or at the bystander witness. Either way, he shot the gun. Um, and he then called CM later that day and threatened her, saying he would shoot her if she went to get a restraining order. But she did anyway. She put forth in the affidavit the facts about that particular incident in the parking lot, as well as previous incidences that had happened where she feared for her life. And she also, her young child, referred to as AR, is also the is AR's father was Rahimi. So she also feared for the life of her young child. So the court did grant the restraining order, and it prohibited Rahimi from making any threats to CM, prevented him from even contacting CM unless it related to the care of AR. And the restraining order importantly suspended Rahimi's gun license for 2 years. So this he did not like. So um, he quickly violated the restraining order. He approached CM's house during the night, just a few months after the restraining order came down. That led to his arrest. He later threatened another woman with a gun. While he was under arrest for that violation, police actually connected him to about 5 other shootings. And these took place in a variety of altercations. One was during an illegal drug transaction. One was actually several were during road rage incidences. So car accidents or just yelling at other drivers and shooting. He even shot a gun into the air in a restaurant when they declined his friend's credit card. So really kind of quick to use his gun, to say the least. So police obtained a search warrant for Rahimi's home following all of the information about all of these other incidences. They found a pistol, a rifle, ammunition, and a copy of the restraining order. So Rahimi was then indicted under a federal law, which is 18 USC, United States Code, Section 922G8. And that is a federal law that prohibits the possession of a firearm or ammunition by a person subject to a restraining order. So Rahimi moved to dismiss the indictment against him, contending that this law, Section 922G8, violates his Second Amendment right to bear arms. The federal district court denied his motion to dismiss, but and he did plead guilty. But then on appeal to the Fifth Circuit Court of Appeals, that court held for Rahimi. And they based it on a U.S. Supreme Court decision that had just come down while this case was pending before the Fifth Circuit. Long name to this case, New York State Rifle and Pistol Association versus Bruin. Um, so the Supreme Court granted certiorari in this case because it really kind of it required the court to kind of take a look at its decision in Bruin and determine if the Fifth Circuit really had applied this in the correct way. And so um, it's important to take a quick look at SCOTUS's opinion in the Bruin case. Now, this was written by Justice Clarence Thomas, who is very strong on originalism, which is where you focus on the wording of the Constitution. You go back to the days of the founders, to the Minutemen, basically saying that we determine if a gun law is constitutional by kind of going back to the days of the Minuteman and seeing if there was something, if there was a law in place that was similar to the law being challenged. So very original textual kind of approach. Um, so the new standard, and I should mention briefly the previous test as it's mapped out at the bottom here, the court would balance the government's, say the state's justification for passing a gun law, usually of course for public safety, um, against the person's Second Amendment right to bear arms under the so it made more sense to do that balancing test. Usually that's kind of the approach done for constitutional rights. You weigh the state's interest versus the interest of the individual who is contending their constitutional rights were infringed. Um, but in the new standard that Clarence Thomas set out in the majority opinion that he wrote, was that for upholding restrictions on gun laws that are passed by the states, um, the laws imposing these gun restrictions will be held constitutional only if the state can show there is a historic tradition of that type of gun restriction. The way he referred to it was a historic analog that was in place at the time of the founders. So we're going way back to 1791, the time of the Bill of Rights, and really pretty much up to 1868 when the 14th Amendment, the 13th, 14th, and 15th Amendment went into play. So this is old times we're looking at, where the use of guns was quite a bit different. So the new test, again, very favorable to the right to bear arms, and very unfavorable to states who are trying to protect the public because things that we have today, the technology of guns. If you think of machine guns and the harm that they can do compared to say a musket as being held by that Minuteman. So quite a bit has changed over the years. But Clarence Thomas said, nope, have to stick with history. If there wasn't that type of gun law back then it's not going to be valid now. Um, so that's what the Fifth Circuit Court of Appeals in Bruin relied upon. Just to give the facts of Bruin, so you kind of see the context, in Bruin, SCOTUS struck down as unconstitutional New York's 100-year-old concealed carry law. So this was not some new law. It was in place for 100 years. And it required individuals to demonstrate proper cause, as the term was, or some type of special need as to why they need self-protection. For self-defense, for example. So if someone, maybe someone feels they're being stalked, or maybe, they're kind of the target of criticism for something. So there's some special thing where they fear that when they go out in public, they may need a gun for self-defense. They have to show that to obtain an unrestricted license to carry a concealed gun outside the home in public. And the court said that this requirement, this proper cause requirement, cannot be sustained. It's unconstitutional. And when in reaching this determination that this New York law violated the Second Amendment right to bear arms, SCOTUS applied originalist theory, as I mentioned before, considered only the text of the Second Amendment and the firearm regulations prior to or at the time of the ratification of the Second Amendment. Now, under this standard, the originalist standard, if the firearm regulation is something regulated in the 1790s or analogous to the firearm regulations of the 1790s, the law would be upheld. if the gun restriction has no historic analogy or historic twin, it would be struck down as an unconstitutional violation of the Second Amendment. Um, so the Fifth Circuit Court of Appeals um, in Rahimi applied this newly released Bruin standard and held that Rahimi's conviction should be overturned because there were no laws relating to domestic violence and restraining orders back in the days of the founders. So the Fifth Circuit struck down the federal law, 18 U.S.C. 922, saying that this violated the U.S. Constitution, Second Amendment. Um, and so this was this kind of a scary precedent that the court set because everyone was worried that, you know, if 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 this is going to be the case, then state laws that are put in place to protect the public, to protect victims of domestic violence, are just going to be struck down. But luckily, SCOTUS took a look again at its decision in Bruin and decided to clarify it and made it much more modified it, let's say. So the court reversed the Fifth Circuit's ruling in Rahimi and said that the appeals court, the way that Chief Justice Roberts stated it, is that the Fifth Circuit Court and other courts of appeal and district courts are misunderstanding SCOTUS's opinion in Bruin and took it too far. They followed the decision pretty literally if you go back and read that decision, but the court, SCOTUS, knew that if it stuck with such a very strict approach in analyzing state laws, there would be very few laws that states could pass to protect people from violence. So the way Justice Roberts said it is that some courts have misunderstood the methodology of our recent Second Amendment cases, meaning the Bruin case. These precedents were not meant to suggest a law trapped in amber. And he went on to emphasize that the Second Amendment permits more than just those regulations identical to the ones that could be found in 1791. So he made it clear that, we look to the kind of the policy, we'll look to the type of law in general. We don't need a historical twin that was in place in 1791. So that's what Justice Roberts was really emphasizing, that courts don't read it so literally, and basically said that the court that is analyzing a gun regulation, one that's being challenged, it has to determine whether the law is relevantly similar to laws that our tradition is understood to permit. So applying faithfully the balance struck by the founding generation. So still going back to the founders, but more, the overall principles and to more than the circumstances. So at least now the court is recognizing that it's a far different situation when we're looking at guns in today's world and gun violence and mass shootings that really were not part of 1791 when they had muskets. So under the modified Bruin standard that Roberts then set forth, he said that when looking at Rahimi, in the Rahimi case, he found historic analogs in place, and said that the founders did bar people from misusing weapons to harm or menace others. Those were referred to as going armed laws. And they prevented people from going armed in a way that threatened the public. Also, he pointed to surety laws where if there was evidence that a person was going to be violent, then as really kind of a form of preventive justice, it required individuals who were suspected of this future misconduct to post a bond or go to jail. So kind of a way to prevent violence, much like laws such as the federal law that prevents domestic violence defendants from having a gun. So finding that historic relevancy to going armed and surety laws, Roberts did uphold Section 922 G8 as constitutional in the Rahimi case. But you can see the role that the Bruin case plays here. So just to kind of sum up what the court held in Rahimi, this is really the first line of the case, and Chief Justice Roberts really said it very well. The overall ruling is that when a restraining order contains a finding that an individual poses a credible threat to the physical safety of an intimate partner, that individual may, consistent with the Second Amendment, be banned from possessing firearms while the order is in effect. Since the founding, our nation's firearms have included provisions preventing individuals who threaten physical harm to others from misusing firearms. Uh, and as applied to the facts of this case, Rahimi, Section 922 G8 fits comfortably within this tradition. So therefore showing that it doesn't have to be this historical twin, as long as it's kind of, following that same principle that was happening back in those early days. And so as this photo shows that, domestic abusers under restraining orders do not have a constitutional right to own guns. So this key federal law was upheld so that if someone is a defendant and they have a restraining order placed on them, they cannot own a gun. And so one of the things I just wanted to mention too is that Justice Sonia Sotomayor wrote a concurring opinion in this case. And by the way, the only dissenting judge, it was an 8-1 decision in Rahimi, the only dissenting judge was Clarence Thomas, who was sticking strong to his originalism approach. But Sonia Sotomayor made a very good point saying that while history has a role to play in the Second Amendment analysis when a gun law is being challenged, it's not good to have this rigid adherence to history, and particularly history predating the inclusion of women and people of color as full members of the polity. So pointing out that really there were no laws back then preventing domestic violence and providing protection for victims of domestic violence. And to do it that way, to focus only on rigid adherence to history, it impoverishes constitutional interpretation and hamstrings our democracy. So a very powerful quote there of the problem with following that Bruin approach. So hopefully the court has kind of clarified things, and still many are wary that a state law may be struck down that is put in place to prevent gun violence, but it's a much better interpretation than the court had in the Bruin case. And it's so important to think when we think of history, the difference between the militia, the Minutemen with a big musket of the 1800s versus the militia of today. So quite a few differences. I also just wanted to point to the really good article that you might want to check out that talks about not only the Rahimi case, but also the Bruin case and sort of the previous cases involving the Second Amendment. It's a really nice, brief overview of the Second Amendment and the constitutional issues involved. So that is it. Thank you for listening. Take care.